In this video, we'll cover the process, how to apply for an immigrant visa from overseas. Essentially, we'll break down the consular process, what you need to know as you get into the immigration process in 2023. So, if you're interested in this topic, I'll see you on the other side. Hello everybody and welcome back to Immigration Channel. This is a place where we get the most up-to-date immigration news, immigration information, and everything else that you need to make your immigration journey less stressful. In this video, I'm going to explain to you the process of applying for an immigrant visa from overseas, from abroad. We'll talk about who needs to do consular processing, the difference between CR1 and IR1 visa, some of the issues you need to know about consular processing timelines, those may change in 2023, and all the other things that you need to know if you're going to start getting the immigrant visa from overseas. Before we do that, if you're visiting our channel for the first time, please subscribe to our channel. Also click the notification bell so you don't miss any of our videos, and also give us a big like so YouTube will be able to show this video to more people just like you. So what is consular processing? Consular processing is the application process of applying for a U.S. visa from overseas, not from inside the United States. And as you know, the green card process is very different for applicants that are currently inside the United States as opposed to people that are waiting for this whole process in their home country. If you're applying for the immigrant visa from overseas, you're going to go through the consular processing. For example, if you're applying for a marriage visa, you'll be getting something called CR1 or IR1, and I'll explain the different categories in a few minutes. Consular processing is also very much different than adjustment of status, because if you apply for an adjustment of status for a green card inside the United States, you can be inside the United States with your family member, let's say a spouse or a parent, while the process is going through. You're also going to get a temporary benefit like a work permit and a travel document. When you go through the consular processing, you have to wait for the benefit of the green card outside of the United States, and you don't get a work permit or a travel document because you are waiting for this outside of the United States. So who should apply for a green card through consular processing? Typically, this is for applicants who are currently residing outside of the United States. They're not able to come to the United States, and even if they are able to come to the United States, they're not able to stay here for the duration of that process. Therefore, they opt out to process their application through a U.S. embassy abroad. Once again, only people who qualify through a green card through marriage, other family petition, or employment should apply for consular processing. For example, you will apply for your I-130, which is the immigrant visa based on family petition, or the I-140, which is based on employment. And once that petition is approved, your case will be sent to the National Visa Center, which is an agency that is in charge to process your application between the U.S. Immigration Service and the embassy. They'll make sure they'll collect all the relevant documents and get you ready for your visa interview. In our practice, we process a lot of consular processing cases. We help clients start their cases from the I-130 petition, family petition, all through the National Visa Center, and finally support them at the U.S. Embassy stages. Remember, when you're dealing with consular processing, you essentially are part of a three-step process. Filing your petition with the USCIS Immigration Service. Once that's approved, case goes to the National Visa Center, and finally, your case will end up at a U.S. embassy for an interview. If you're going through a case through a marriage petition, you're typically going to get a classification at the embassy on your visa as a CR1 or IR1. What's the difference? If you've been married to your spouse less than 2 years, you're going to get a conditional green card designation called CR1. And once you get to the United States, you'll be able to file for removal of conditions on Form I-751. If you're married for more than 2 years, you'll get a permanent green card with classification as IR1. Let's run through the procedures of consular processing. First of all, let's make sure that you're actually eligible to do this. For example, if you've been in the United States undocumented and you came here multiple times back and forth, you're probably subject to the permanent bar. You're not eligible to apply for any visa, whether it's in the United States or abroad. So you should avoid doing that. If you're going to leave the United States and end up at the U.S. Embassy, you could potentially severe some penalties. So the first step is see if you qualify. You have a U.S. citizen spouse, you're a beneficiary of another family petition or an employment-based petition. Then you file your I-130 petition, family petition with the USCIS, the Immigration Service. Currently, most of these I-130s are pending about 14 months average. Once that petition is approved, the USCIS will forward your case to the National Visa Center. The National Visa Center, also known NVC, is part of the State Department, and they are in charge of processing the applications before your case ends up at the U.S. Embassy. During the NVC stage, you'll have to complete Form DS-260 online, and submit all the required documents until your case is deemed documentary complete. And your embassy has interview slots available. MVC will send your case to the U.S. Embassy. Once your interview is scheduled, you appear for the interview, you'll bring your passport, your other documents, and hopefully you'll pass that interview. Once you pass the interview, the consular officer will give you a visa for 6 months and an envelope for you to take to the port of entry when you arrive to the United States. Remember, your visa is only valid for 6 months, so make sure you travel to the United States within the 6 months. Once you come to the United States, CBP officers will process your application and your green card will be mailed within 2 to 3 weeks. What is the actual timeline for consular processing? Well, based on our experience, the average time, the faster we've seen it, was 18 months from start to finish, and the longest we've seen was 37 months. So it's anywhere from 18 to 37 months to finish consular processing, depending on your category and depending on which country you're coming from. So that's the consular processing in a nutshell. If you're going through this application, please consider carefully whether you should do adjustment of status or consular processing. And if you are doing consular processing, it is very important for you to be patient because it's really taking a long time, specifically because of these backlogs that we've seen in the past 3 years. As always, my name is Jacob Sapochnick. I am an immigration attorney based in San Diego, California. And if you need help with your consular processing or any of your immigration matters in 2023, all you have to do is send me a text right here, 619-483-4549. Let's schedule a consultation and start this year the right way. Thanks for watching, and I'll see you in the next video.